Okay, so we're on our journey through business law with contracts. This is really one of the most important things that you have to understand as a business person. Contracts are everywhere, whether they're actually implied or expressed. Their contracts are everywhere in business. And so this is one of the reasons you have to take in all business programs across the country a business law course, is because you have to sort of get an understanding of contract. But a contract basically is important because it's a legally enforceable agreement. That's the key, right? Legally enforceable agreement between two or more parties who promise either to do something or not to do something in exchange for usually a payment. And in terms of contracts that you have been involved in without even knowing, you've been involved in implied contracts all the time because you've probably been out to eat at a restaurant. Likely you've probably gone out, sat down, ordered a nice meal, eaten a nice meal, and then have to pay the check, right? And so that's an implied contract. You didn't have to sign anything when you came in, you know. You didn't promise to order anything and then promise do something because of that. It's an implied contract. So this happens all the time. This happens all the time. And then, of course, there are very specific expressed contracts in which there are oral and written promises and have terms to the agreement. And actually, everything that you usually do, particularly online, a lot of you will have, various accounts on various websites, social media, or others. You might have email account that's free through Google or Yahoo or Hotmail or what have you. You're actually entering into a contract when you have a Facebook page or a Snapchat page or Instagram page or whatnot. You've entered into a contract, and the terms of those contracts are important to understand that you have entered into a legally enforceable agreement. Okay. Now, normally, they'll come up with this is free. You get a free account. I will tell you, there's nothing for free. There's no such thing as a free lunch. Is an old economic concept that's very true in life. There's nothing for free. What you're giving up when you decide to have, say, a Facebook account or Instagram or a Snap account, or even get a free email account from Google or Microsoft, is you've given up privacy rights. The certain expression that you have in writing is that you do have free use of this board on Facebook or social media or this email, but you've also given them the right to, in essence, look at everything you've done and use that information to gather. So anything you've posted is information about you. You might be posting that you just bought something. You might be traveling somewhere. You might be having difficulty with health or other types of things. Anytime you post those types of things, it now becomes marketing material for that company to use and sell to companies who might be interested in having you as a customer. So it might seem like free. Nothing is free, that I can guarantee. But for a contract to be valid in court, legally enforceable, there are 5 very specific requirements that it has to happen. One is you have to be doing this freedom of choice. This is a free, voluntary agreement. No one's forcing you to do it. You're freely choosing to use a particular service, or you're freely choosing to sign a particular contract because you want to, voluntarily. So that's one. Two is there's got to be some consideration. So consideration in this case is something of value. Most likely is money exchange, but it doesn't have to be money exchange. It just has to be something of value. And that's what consideration is considered here. Competence means that you have to be able to sign a contract. You can't be drunk or high or or out of it in one way, shape, or form. You have to be 18 and older, or in some cases, if you're less than 18 and you're already emancipated, then you can. But there are, standards of legal competence that all parties involved in the contract must meet for it to be legally enforceable. Of course, the contract has to be for something legal, something lawful. You can't bring someone to court. So I paid this guy $5,000 to kill somebody. Okay, well, that's not a lawful subject matter. It might be considered a contract in people's heads, but it's totally unlawful to do that. And so it's not a lawful subject matter. So you can't be dealing with anything that's against the law and have a contract for that and expect it to be enforceable or valid. It's not valid at all. And then there's proper forms. Again, in many cases, contracts is it's a state law type of thing. So there has to be some particular form that you'll see that they have to follow. Okay. So again, voluntary agreement. It's, basically you have to agree. One party cannot bind the second party into a contract if the second party doesn't agree. Which is why they always ask you, did you read the terms and conditions of the offer before you accept it? Now, in many instances, we don't. And so this is where they get us for, high interest rate credit cards or tricky loans. We're not reading all the terms and conditions before some of us sign on to something. We're certainly not doing that when we agree to the terms and conditions to use an app or to use a particular site. But in essence, we should be understanding that these terms and conditions could be something we don't want to agree to. Okay. And if it's not accepted, there's no contract. Okay. So this is very, very important. Again, consideration, as I mentioned, something of value or benefit that is exchanged between the parties. So again, legal competence, as I mentioned earlier, no minors. So if you're not technically an adult or an emancipated adult, you're not bound by any particular contracts. Okay. If you are of unsound mind, if you are intoxicated with either alcohol, drug, or whatever, then you're not legally competent to enter into a contract. You don't know what you're doing, in essence, what they're saying. Lawful subject matter, again, if you're agreeing, if you have a contract to do something unlawful, sell drugs, contracts on other people's well-being, whatever, those are illegal to begin with, and so you're not going to have a contract in that regard. There's a term that it's an older term, but basically the term is usury. So usury is about charging interest in excess of the legal rate. Now, again, you should understand that your state government is they are regulating the banking system. And so your state government, also the lending system. So state government tells the banks the most they can charge for interest based on a customer's, based on the type of loan it is. And so the most they can charge in New York for various loans might be no more than 24%, for example. Well, you can't be in the state of New York and make a loan for 50%, right? Because that is charging interest in excess of the maximum rate allowed by law. Okay, so that's really what usury is about. Okay. Now, a proper form, in essence, written contracts must have certain things. So, in terms of the proper form, we're looking at if you have a written contract, it should include the names of the parties that are involved. You should need to sign it. What's the purpose of it? And again, it should list all the terms and conditions of what you've agreed to. The signature basically binds you to the terms and conditions of the contract. You know, this, your student loan, by the way, some of you have student loans. You're signing a contract. Part of the contract terms and conditions is, in essence, you're borrowing money that is a federally sponsored program. So most student loans are federally sponsored programs, which means, in essence, even though you might be getting the loan from your local bank, you actually have a contract with the federal government, the Department of Education in Washington. And part of the terms and conditions you've agreed to is even if you don't finish your college education, you got to pay it back. Student loans are not, they're not allowed to be offset in bankruptcy court. So they're exempt from all the rules in the bankruptcy court. A lot of people say, well, I'll just declare bankruptcy and I won't have to pay back the loans. Well, for some loans that works. For other loans, it doesn't. Student loans, it doesn't work. You're going to owe that regardless. So just really be careful on how much you borrow to go to college. Because part of those terms and conditions, and as soon as you sign it, it's a done deal. It's a contract. Some states require that in order for a contract to be legal, it has enforceable. It has to be in writing. So anytime you buy real estate, the certain amount of it's going to be in a proper form. You can't buy real estate with a handshake. Say, okay, here's $100,000. It's my house now. It's not how it's done. So there's a number of different things that are required to be in writing in order to be enforceable, and that's called the statute of frauds. Okay, that's just a law that was passed that requires that certain contracts must be in writing. And let me sort of list this here. Okay, so here's an example of a contract. This is in the reading. Remember, you have a PDF file to read in this. It's not the normal part of your book because it's an appendix, but the PDF file is given to you free on Blackboard. Right? So again, part of the contract are they legally competent to go into it? Is it a lawful subject matter? Is there consideration? In this case, it's a payment. And it's voluntarily agreed to by, in this case, it's a contract between a company and a homeowner to do a sprinkler service for $5,200. So again, the company will sign it and date it. The homeowner will sign it and date it. And this technically becomes a very legally enforceable and valid contract. So in the case that the company, the sprinkler system company, doesn't do what it says it's going to be doing, then in this case, the homeowner has a legal basis in which to sue. The opposite is true. If the homeowner doesn't promise to pay for the work that's been done, then the company has a legal right to sue because now they have a contract that they can show the court, and the court can determine whether that contract was violated. Okay. Part of contracts are involved. One of the questions is, were all the obligations of the contract fulfilled, which is called performance. So when you make a contract, you have both parties have agreed to certain obligations. So for the case of the sprinkler system company and the homeowner, the company has agreed to put in a sprinkler system um, properly, we're assuming, and the homeowner has agreed to pay. So once the system is done and put in the ground and the homeowner pays, that contract is said to be been performed. And so performance, all the obligations have been fulfilled. Non-performance means that the parts of the contract, some or all parts of the contract, were not performed. And that's what a breach of contract is. Okay. A breach of contract is really when one party fails to fulfill its obligations in the contract. Okay. And there are no legal reasons for that failure. Okay. And so breach of contract is something that's very important in your life and in business life for sure, because there may be times where people or businesses that you're doing, that you have a contract with, might not perform all of the things they said they were going to do, in which case that's a breach of contract. So this it happens in even leases. If you rent a place, you have obligations as a tenant, but your landlord has obligations as well. And a lot of times you'll end up with, sometimes you'll end up with a breach. You have to take it to court. But again, you have to prove the failure of that party that didn't fulfill the terms of the contract. So there are certain ways in which, how do you remedy, in essence, or how do you get a breach of contract settled? Well, you could both agree to terminate the rest of the contract. And so that's called discharge of the contract. So you basically said, okay, I want out. You didn't do this. I'm not paying you for the rest of this. I want out of this contract, and the other party agrees. Okay, fine, get out. Done. Breach of contract, but it's resolved. It could be that the breach was so bad that it resulted in damages. So damages really is a case where one party was hurt so badly by the breach, by the failure of the other party to fulfill its terms of the contract so badly that in essence they needed damages. They were awarded damages by the court because the party showed that they were injured. Injury in court is basically a loss. Okay, so you have to prove a loss to prove an injury to a large degree. Okay. Or you can resolve a breach of contract by the parties actually fulfilling their obligations. Okay, I'll finish this up, no problem. And they do. That breach of contract is resolved. And so breaches of contract happen a lot, but there are certain ways in which they can be remedied. I think you've probably, one way or another, might have entered into a sales agreement. You bought something from someone else and you had an agreement. This happens with buying a car, a used car from people. You need a contract for that. Sales agreement basis a contract. And so basically speaking, sales agreements tell us when the ownership has transferred from the seller to the buyer. So Jack has a car for sale. I'm interested in buying the car. Right now, Jack owns the car. After I buy the car, I show the sales agreement, among other things, to the registry, and then they can change the ownership from Jack to me. That's the purpose. That's one of the big purposes of that sales agreement, is now I can prove the ownership is exchanged. I can prove the payment to him, blah, blah, blah. And now the ownership can transfer. And so sales agreements are very important aspects of business. And then there are warranties. There's something called an express warranty, which is simply a written explanation of what the seller or producer manufacturer would do if the product is defective or not, or unsatisfactory. So almost all products that you and I buy, whether it's cars or computers or even, a vacuum cleaner, even a bedroom light for your desk, or maybe a desk light, they all come with some type of warranty. And oftentimes it's a 90-day warranty for smaller products. Some cases, it might be a year warranty for cars and stuff like that. You get anywhere from a 3-year warranty to a 10-year warranty. So, so these are written explanations that if in some way, shape, or form what you buy is defective, is not what they promised, they'll fix it, replace it, whatever, at no cost to you. And that is a very important aspect of doing business. You want to have, particularly if you're selling products, you want to make sure that the people who are buying your products are certain that they're going to work and that you stand behind those products. And so you'll often hear about your money back guarantee. That's basically expressed warranty. And then there are implied warranties, which in many cases are required by law. Okay, so you have a lot of rights as a buyer dealing with businesses. You could need to assume, in essence, part of the law requires that the merchandise that you're buying is not stolen. In other words, it has a clear title. Title is a certificate of ownership. So you know that it's truly theirs and it can be transferred over to you. The merchandise is as advertised. Now, this is one of those really interesting things. Car dealers get away with this quite a bit. They'll advertise, we have this brand new 2020 vehicle and it's only $10,000, but you got to act now. Well, they might have one car that's $10,000. All the other cars are not. Technically, they've met the burden of the law because they actually do have a product for sale for $10,000 that they advertise. But it's simply to get you in. It's simply clickbait, or just in essence, trying to get you in. The merchandise basically has a purpose. The reason you want to use this machine is because it does this, or this product does that. So part of the rights you have as a buyer is that whatever has been manufactured and it says it's going to do this, it's going to do that. That's something that's implied. So businesses have to make sure that if they're saying the purpose of this product is to do this, that it actually does it. Okay. The next part of this is about property, because as you know, businesses own property. They own buildings and land and other types of things. So property, in essence, is anything that can be owned. Okay, anything that can be owned. And so real property is considered land or anything that's permanently attached to it. Okay, so like a building. So that would be considered real property. Real property require proper form for contracts. And then, of course, there is personal property, which is anything other than real property. So it could be pieces of equipment, like computer equipment, or it can be, so it's tangible property, or a vehicle, or it can be intangible property. So a tangible property has a physical appearance. So your car, equipment, like computer equipment, they have physical value. Intangible property does not have that physical trait, but it has value because it's a legal right that's given to you. And your book introduces you to a couple here. I'm going to focus first on the patent. So a patent is basically the government recognizing you as the owner of some invention. Okay. And as the owner of that invention, you have a right to make it, use it, sell it, do anything. And so patents are actually quite valuable. Now, you and I might have, we might have gotten sick and needed to take a particular drug. Or you might have heard on the news that, there's a couple of promising drugs for COVID that's being used. So anyway, those drug companies would have a patent on that because it's technically their invention. And that invention, that patent, gives them the exclusive right to make it. It's one of the reasons why we have such high drug prices in this country, is because we have a lot of great drugs that are new and do a lot of different things. But because of the patent on that, it in essence gives a monopoly on that drug to the drug company who makes it. And if you have a monopoly in a product, there's no other sellers of that product. And that means you can charge whatever the heck you want for that product. And that's why we pay, as Americans, the highest drug prices in the world. But we also have the advantage of, the creativity of getting those new drugs. So it's a, every system has pluses and minuses. There's no perfect system. So that's one of the pluses and one of the minuses for sure. A copyright is the exclusive right to publish, perform, copy, or sell an original work. So this is for a lot of artists, and a lot of people like music. And so when you make music, you want to have that music copywritten to show that you own it. You have the exclusive right of performing it. So whoever your favorite artists are that are performing music, they have copyrights on the music, on the lyrics, on the music that they use to sing those particular lyrics in the song. This provides them with the exclusive right to do it. Other artists can't do it without their permission. Permission comes in the form usually of payment. And so, it just so happens it's a very important copyright. I want to, and you might not know this particular issue, but you probably have all heard, let's make sure I got the song here. You probably have all heard this song before. Have you heard this song before? Give, a thumbs up, just so I know you've heard it before. Has anyone else heard this? I only have one thumb, a couple thumbs. Well, anyway, that beat, doon, 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 with the woo in the background, I'm not a very good singer, but I'm doing my best here. Believe it or not, there was a group back in the 70s that actually created that music and had a copyright on it. And of course, they're much older now, obviously. If they were doing music in the 70s, they're much older now. So when Robin Thicke, etc., came out with Blurred Lines and they heard that, that beat and the woo, they said, that's our song. That's our music. They never asked us permission to use it. And yet they're making money off of our music. So they had a lawsuit against them because they were able to prove in court that that music was their exclusive right to perform. And that Robin Thicke and company never asked them permission. In essence, they stole the music to make profits from. So because that song was very popular and made a lot of money, they were able to prove injury, a loss. And thus they were rewarded by the court a sum of money to make up for that injury. That's how important copyrights are. Copyrights apply to music. They also apply to software. All your apps are copywritten. You have a lot of companies that actually they totally exist because of copyright. Disney, all of the Disney characters, regardless whether they're traditional Disney characters like Mickey Mouse and Donald Duck, or the newer Disney characters like all the Marvel and Star Wars. They're all owned. They're all copywritten, owned by Disney. No one else can use that without permission from Disney. And so they're very, very important assets for the company, and they use that. Trademarks are very similar as well. Again, they are registered with the Patent and Trademark Office, where the government officially recognizes a certain word, phrase, symbol, or design that is owned by a company. So you can't do anything in the Dunkin' Donuts, the Starbucks with its mermaid and everything. That's owned. That's a trademark for this for the each respective company. You know, Google is when you Google something, that's a phrase or a word that is synonymous with searching, right? Apple has its the little apple with the little bite mark on the side, right? That's that's a trademark for Apple. Walmart has that odd looking sun or whatever it is. Those are all trademarks. McDonald's has the arches, blah blah blah. These are actually owned by these companies. It's a property of these companies. So no one else can use any of that stuff without infringing on property. It's easy to know. I mean, this is where intangible assets are really interesting, or intangible property is interesting, because how do you prove someone stole it? Well, it's easy if you have a lot of, say, you have a ton of stereo equipment in your house, and you walk into your house one day and it's all gone. Oh my God, all my equipment has been stolen. Yes. Well, it's a little bit more difficult to know that your music and your words or other types of things are stolen by other people for business purposes. But in essence, it's best to have ownership of those. So if you do find out it's stolen and being used, you actually have a basis to prove injury and have a lawsuit. Okay. Ownership of property is transferred all the time. Okay. You can purchase it from other people, you can gift it, or you can inherit it, right? And so there's a couple of things that are revolving around here. So a deed basically is that written document proving ownership of real property, land, buildings, things like this. They will have a deed. If you have a house, it has a deed. Okay, that's the proof of ownership. In essence, another way to indicate at least temporary use of it legally is a lease. Is a lease. You have that exclusive right to use certain things. So in essence, it's temporarily transferred to the owner. Even though I don't own my apartment, my condo here, I rent it. My lease gives me the exclusive right to use it. So it's technically temporarily mine for the period of time that I signed that lease. The owner just can't decide to walk in anytime. But he does own the property, but he does not have the right to just show up because he has given me that right through the lease. So he's given up some of that. That's important to know your rights and to know whether a contract is being violated or not. So in essence, these are ways in which the transfer of ownership of various things is very, very important to sort of understand. And this affects businesses and people, which is why it's in this chapter. Okay, there are laws that are related to what we call a negotiable instrument. A negotiable instrument, in essence, is a substitute for money. Most of us use checks, for example, as a way to do it. So checks are the most familiar negotiable instrument that there is. And that's because a check basically is a promise to pay. It doesn't reflect cash. It actually is a promise to pay cash to the person or the business that's written on the check, and it's signed by you. which means that once it's signed by you, it can be transferred. It can be transferred. So checks are simply promises to pay. A check is not technically cash until it's transferred. And so you're going to be learning, particularly in business law 102, 201, 202. So the second business law 2, about what we call the UCC, which basically establishes various conditions about these types of things. All you need to know about it here is that a check is the most common negotiable instrument. And there are laws that are, believe it or not, need to be followed even when dealing with checks. So first of all, the endorsement, okay? To make sure that you're able to transfer money from your checking account to the other person, that person must sign it on the back, okay, of that check. That's what an endorsement is, the signature on the back of a check. And there are basically 3 types of endorsements, okay? Something called a blank endorsement, which is just your signature. That's it, nothing else on the back, but just your signature. The second is something called a restrictive endorsement, okay, which states the purpose of what the instrument's going to be used for. And we'll show you what some of these are. And a special endorsement identifies the person or firm to who the instrument is payable. So let's take a look, because I think there's so here's a chart here. So this is a negotiable instrument, a check. In this case, Maria Martinez wrote a check to Charles Hall for 25 bucks, okay, for tutoring. And she signed it, okay. So this is her order to pay. This is, she's telling her bank, National Bank, that with her signature, she wants National Bank to allow $25 to be transferred out of her account at her bank, which is what these numbers are for, to Charles Hall. Charles Hall has to endorse the back of the check. This is how Charles Hall can do it, okay? A blank endorsement is simply the writing his name on the back of a check. That's it. That's called a blank endorsement. I don't think you should be using blank endorsements on your check, personally. Much better to use something called a restrictive endorsement, which, as you see here, is endorsed by Charles Hall, but it's telling the bank it's only for deposit only into his account. That's a better endorsement because it restricts it. So if I picked up a blank check that just had a check rather that had a blank endorsement, I could sign it and put it in my account. So there's some problems with a blank endorsement because it sort of leaves it open. As soon as Charles Hall just signed the back of the check, he said, yeah, that's okay. And now I can do it. He can give it to me or whatnot. So in essence, restrictive endorsements are much better. And then, of course, there's a special endorsement, which in case Charles Hall is allowing this check to be given to another person. So he's using this particular $25 to pay somebody else without him himself having to write a check. And that's a special endorsement. So he signs the back and he says, look, this check is really going to be for Robert Jones. And so now Robert Jones can sign the check. And it'll be for him. So these are the endorsements for those checks. Okay, very interesting. You probably never thought so much that there's so much to signing a check, but there's actually a few things. Now you know. All right. The next thing is something called agency law. So when you're dealing with this idea of a legal concept called agency, it's basically is when you have appointed someone called an agent to act on your behalf, okay? To act on your behalf. And so most agents are independent business folks or independent companies who are paid for the services in the form of a fee or a commission. And usually, specifically, you are only hiring the agent because they have a special knowledge for a purpose. So, for example, here, you're hiring a real estate agent to represent you in getting a real estate deal done because the real estate agent has specialized knowledge about the real estate market and how things work. And they're supposed to be helping you on your behalf. Okay. And so once you've actually signed or hired an agent or an agency, under the law, whatever that agency does is now legally upon you because you've, in essence, given the agency the right to act on your behalf. And so whatever the agency decides to do on your behalf now becomes legally your responsibility. The best way to manage any of this type of stuff really is by using a power of attorney, but a limited power of attorney, which is a legal document that serves as the evidence that you have appointed a person to act on your behalf. And so powers of attorney can be used for anything. So it's basically just like you've given, and they can be limited. A general power of attorney is just then whoever you've given the power of attorney to can do almost anything on your behalf. That's dangerous. You don't want to do that. You want to limit them to certain things. So there's a financial power of attorney to deal with certain financial things. There's a health care power of attorney, which gives them the right to do decision-making over healthcare. In the case of a real estate agent, you've given them certain rights to help you buy or sell your property. And so they, these are all what we consider. So you might go to work for a company that you're an agent for someone. You have that special responsibility that you're representing someone in a business transaction. So whatever you do, you just need to know is going to be binding on the person who hired you. Yes. The wonderful world of bankruptcy. Bankruptcy is a legal procedure. It's not like just one day you look around and say, that's it, I have no money, I'm broke, I'm bankrupt, and you declare bankruptcy that way. That's not how people declare bankruptcy. That's not how companies declare bankruptcy. A bankruptcy is a legal procedure, okay? And that means that you've gone to the court to say, I am unable to pay these debts, okay? You cannot meet your financial obligations. And that also means that you borrowed money. So there are other people or businesses involved that are going to be affected by your inability to pay back the debt. And so the bankruptcy court and the bankruptcy laws are there to help all the parties involved and affected when someone or some company declares bankruptcy through the court. Okay. So initiating bankruptcy, overwhelmingly, it's because people decide they need to file for bankruptcy. Okay. So the individual or the business can no longer meet its need, can no longer meet the payments that they owe people. And they said, look, the best thing for me to do is to file for bankruptcy and go to court and see if we can work this out. That's voluntary bankruptcy. And most bankruptcies are voluntary. In other words, the individual or business who is having financial difficulty is the one that goes to court and says, I need to declare bankruptcy. I need to work this through. What you don't want to see is something called involuntary bankruptcy, which is when the people who loaned you the money, the creditors, sue you for not paying. That's involuntary. They go through they want to declare bankruptcy in this regard. And so that is basically not what you want to happen. You don't want to happen. So again, bankruptcy is a legal procedure, and there are obviously going to be injuries to parties that are involved because the businesses who loaned your money, which are called creditors, anyone who lends your money is a creditor, they're expecting to get payment back. So when you can't pay that back, that's an injury to that party. And so there are means of resolving bankruptcy. Um, the worst case scenario is full liquidation. It's when the court actually orders all of your assets to be sold, and the money will be collected by the court to pay back your creditors. This is where auctioneers get a lot of their business from the bankruptcy court, because the court will appoint the auctioneers to sell all the assets. The auctioneers will then document all the sales and the prices they've received for those assets. They will take an appropriate fee, which has been agreed upon, and everything will be remitted to the court. The court then will have a pile of money and decide what lenders are going to get paid and how much each lender is going to get paid back. So it's the worst case scenario. Liquidation is the worst case scenario. You hate to see that happen, but it has happened. It has happened. Radio Shack, Toys R Us, have all gone through basically liquidation. You know, they're out of business. They sold off everything, and it's a sad scenario. Right. What's most common is a reorganization. Okay. And a reorganization basically is now the court basically decides in some way, shape, or form, based on all the information it has about your case, whether they can reorganize the debts so you can still pay them back and keep the assets that you have. And so reorganization, bankruptcy through reorganization, is one of the most common ways corporations file for bankruptcy. And so you've heard about a lot of companies recently, particularly in the retail industry, filing for bankruptcy. Even the airlines have always threatened to file for bankruptcy. What they're filing for isn't to go out of business. They're filing to reorganize their debts. They just have too much debt, and they can't pay it back right now, but they still want to continue. They want to somehow ask the court to reorganize the debts so they can continue. Some reorganization means that some debts might be forgiven, while other debts, other loans, will be restructured perhaps over a longer period of time. So instead of paying something back over 10 years, we might stretch it out now to 15 or 20 years. Well, what does that do? That lowers the payments. And so if you have a lower payment, maybe you can meet that payment instead of the one you already have. And thus you can stay in business for a longer period of time. So reorganization is really the most common form of bankruptcy case that you'll see. And it's usually for businesses. For individuals, a reorganization is simply, it's a similar type of thing. It's just called repayment, where again, you're filing bankruptcy, but in this case, you're not claiming that you're totally broke. You actually would like to pay back the debt. You just can't do it right now, one of the circumstances, and you're asking the court to set up a new repayment schedule. A lot of people say that's a really good thing to do, but let me tell you what happens in this case. What you've done is every time you get paid, you're going to be writing a check to the court, or the court might even garnish your wages, because what the court has done when they've agreed to grant you bankruptcy protection under repayment is they said, okay, we're going to let you keep your car, we're going to let you keep your house, we're going to let you keep these assets that are important, but now you owe us the money. So we're going to collect the money on your behalf and pay your debts back. So now you're paying the court, and you can't defy a court order, right? So you have to pay the court. Otherwise, the whole thing falls in your contempt of court, which is a horrible thing. So so repayment might sound like a decent thing for individuals. It's just as stressful as being, under a lot of debt. Okay. So here's just a little bit of a step by step here in chapter 7. I just kind of explained it earlier as well. And we're going to leave it there. Now we're going to come to federal regulations, which is a topic for the next class. We're going to be doing all the federal laws during next class.